We have had many parents of high school students, it could be middle school, it could even be elementary school, but it's typically high school students who receive a letter from the principal of their child's school advising them that the child has been suspended for 5 days, and on the 5th day of that suspension there will be a superintendent's hearing. A superintendent's hearing is a vehicle provided by the New York State education law to establish an appropriate measure of discipline when a school district wants a student to be suspended for in excess of 5 days. A student can be suspended for less than 5 days without a hearing, but when the school district feels that the student has done something, whether it's academic, whether it's something like bullying, and I'm sure we know in the state of New York now we have something called the Dignity for All Students Act. When the school district wants that student to be suspended for more than 5 days because it believes that whatever the student has done is so egregious, it must give the student a hearing. And that hearing typically is before an appointed hearing officer paid for by the district, who hears evidence, testimony. It can be watching tapes, it can be receipt of documentary evidence. The hearing officer makes a record, it's stenographically transcribed, and makes a report and recommendations to the superintendent as to whether the person has engaged in the activity accused of and what, if any, discipline ought to be imposed. So that is a superintendent's hearing, and what we often have is a parent coming in on the day before the hearing thinking that they're going to go in by themselves with the student, and we caution people to consult counsel to ascertain whether counsel is needed, one can have counsel, and if not, what are the appropriate ways to keep the student discipline to a minimum.